Hi, everyone. Welcome. Steve Willems here from NAI Keystone. I'm at the law offices of Leisawitz Heller with partner Kevin Moore. Kevin, nice to see you.
Good morning, Steve.
Kevin, what area of expertise do you handle in the law firm here?
Well, I handle all of our firm's labor and employment practice. I also represent a lot of contractors in the building trades and property owners and managers in real estate.
Perfect. That hits all the hot buttons that we want to talk about today in our COVID series. What do business owners, employers, what are the hot topics as it relates to COVID and employees? What are you hearing?
Well, the most important issue that has come up, big change that has occurred, is the realization of something called the general duty of safety that every employer has to its employees, and generally every property owner has to its invitees. Under federal law, OSHA, the Occupational Safety and Health Administration, administers safety laws. And within their regulatory framework is the general duty of safety that an employer has to its employees. Now, that is the general duty to keep your workplace safe. So with COVID-19, every employer has that general duty automatically, okay? How that's implemented, I'll get into in a minute. Separately, property owners, property managers, real estate entities have a general duty of safety, but we characterize that in the world of negligence. You've heard about, slip and falls at all the properties you manage, etc. That falls under the rubric, if you will, of general negligence. However, to establish negligence in this world of COVID-19, law enforcement, government regulators, and yes, lawyers are using COVID-19 compliance as the basis to assert liability and the basis for compliance.
So if I'm a tenant in a building, at least the whole building is a triple net lease, do I have the duty to provide safety, or does the landlord who owns the building have the duty, or do both of us?
Generally speaking, it's first a marriage or contract. So let's look to the lease. Who has assumed that responsibility by way of contract? And the assumption of that liability by way of contract will generally drive OSHA compliance. Okay, for example, landlord in a triple net lease is not going to be giving itself the responsibility of OSHA compliance because it doesn't manage and control the day-to-day operations of the facility. So landlord, most likely off the hook. General duty of tenant. Landlord needs to make sure that that duty is passed on to the tenant, the general duty of safety for occupants, invitees, employees. And again, the general duty of negligence, if you will, is already dealt with the assumption of the risk, insurance, indemnification language, and things of that sort, which are in all commercial leases.
So at this time, not a bad time to revisit your lease, check the indemnification provisions,
Yes.
insurance provisions.
Absolutely.
And if they have questions, you could answer it.
Yes.
That's good. That's good.
Yeah, absolutely. That's a biggie. And if I may, I'll just kind of take the next step further.
Yeah.
And when it comes to the legal precedents, what has happened already? We already had court cases. Here in Pennsylvania was one of the very first lawsuits filed in the country on COVID-19 compliance. And unfortunately, a meat processing plant down in Bucks County had a death of an employee. And the facts alleged in the lawsuit were that the company knew about COVID-19 compliance, knew about CDC guidance, knew about Pennsylvania Department of Health requirements, ignored them, and employee contracted COVID-19 and died. So we now know exactly what the legal theories are being used in state and federal court to pin liability on employers and property owners. They're starting with the statutory obligation of what's called the statutory duty clause, okay, the safe duty of care rather. And they're saying if you violated OSHA, because OSHA has its own guidance for COVID-19, and OSHA adopts and incorporates the CDC guidance. If you're in violation of those, we call that per se negligence. So now you have violation of the COVID guidance, creates the liability. They violated the statutory duty of safety under OSHA, under federal law. There are going to be penalties. They're going to be found per se liable, and that creates the liability for injuries and unfortunately death. Now, what's the missing piece? The missing piece is causation. Scientifically, no one has figured out exactly how to prove how a human being contracts COVID-19. This person who passed away, very easily could have gotten it from their family, at home, at the gas station. It doesn't necessarily follow, so there's going to be enormous amounts of litigation about causation.
So there was one suit filed. Is that the only one, or are there other precedents set as we go?
Well, let me be clear. There has been no decisions made yet on COVID-19. Okay, it's too early. The lawsuits have only started. Okay, and we can't stop a lawsuit from being filed regardless of what we put in our leases or in our indemnification language. But the theories are now being asserted, so employers are reacting and property owners are reacting to what they're seeing as the theories being pled and filed in court, but there are no decisions yet.
Should there be indemnification changes in laws? Are the politicians getting involved in this to provide some level of safety for a responsible owner, business owner?
There is legislation at both the Pennsylvania and at the federal level pending. None have been passed that provide indemnification or hold harmless for an employer or a property owner who is acting in good faith, who is following CDC guidance, who is following DOH guidance. There's been no immunity, if you will, for COVID-19. There's legislation that uses that very language that hasn't passed yet.
Okay. So crystal ball, moving forward, what do we need to look for? What do we need to do? Any advice?
Yes, best advice for property owners and managers is to make sure that their tenants have adopted COVID-19 plans. COVID-19 plan, generally speaking, simply has to follow CDC guidance and Department of Health guidance, okay? That's the best you can do. What are the challenges? Well, we're sitting in the lobby of my law office, okay? I'm sitting here with my firm's COVID-19 plan that I wrote. And you can't see here in the lobby, but we have one-way hallways throughout the building. We have our sanitation stations all over the building. We have our signage. We have compliance. We have our employees acknowledging the rules. Okay, so we're doing everything we can. We have limited hours, all of the things that are appropriate for a COVID-19 plan. However, there are instances, I'm getting phone calls from employers who employees are refusing to come in because they don't believe it's safe, or they don't believe the employer is following the guidance clearly enough, or the property owner who operates the restaurant, okay, and the invitee. That's a challenge. So what commercial property owners and industrial property owners should be looking downstream to do with their tenants is to maybe throw a rider on their policy, on their lease to say, show me that you've got a COVID-19 plan in place, okay? At least they're doing that, and that way, to the extent that there could be a reach upstream for liability purposes, the landlord may have a little better protection.
A lot of stuff to cover, a lot of things to think about.
And it changes every day, as you saw. And even here within Pennsylvania, you and I are sitting here in Berks County, Pennsylvania, which has the 4th highest rate of COVID-19 in the state. Yet if we were to travel to other counties where there are hardly any cases, you don't see as much compliance. The DOH guidance applies to every county in the state. The CDC guidance applies to every state in the country. However, culturally, politically, unfortunately, it's become a political/legal issue. Our governor, withheld federal funding to the county of Lebanon right next door to us, and that county has filed a lawsuit against the governor to release the funds, basically alleging he doesn't have the constitutional authority to do that. So it is obviously it's the mixture of science and politics, but at the end of the day, people like you and I who operate businesses, have to be as safe as possible, and the COVID-19 plan is the best thing for everyone to do, is to have it and enforce it, but it has challenges. our staff doesn't like to wear these masks all day long, but we don't have workstations that are fully and always 6 feet apart from each other. We've staggered schedules, we've staggered people in the building, but while they're here, they have it on. I've got mine on now.
Kevin, we can help you with larger space.
That was a great segue, wasn't it? So it's a big challenge. I think our biggest complaint, if you will, from our staff is having to have the mask on all day, even when they're at their desk, and there may not be someone within 6 feet.
Yeah.
And that's a human challenge that we all deal with.
Have a plan, be responsible. Pay
Yeah,
attention, right?
COVID-19 plan compliance is the best way for any property owner, manager, or tenant to avoid legal liability from the types of claims that are out there. Again, there's been no causation. You can't prove that yet. Science hasn't proven it yet, but it doesn't stop a lawsuit from getting filed.
Okay. Kevin, thank you.
You're
A
welcome.
lot of information.
Okay.
Covered a lot of bases there. We appreciate it, and
Happy to be of help.
we hope you're safe. Can't shake
There you
hands.
go.
There you go. Thanks a lot, everybody.
Thank you.